Hello, and thank you for joining us for Bracewell's Spotlight on Public Finance. Today we will be discussing the final Treasury regulations that were released by the Internal Revenue Service on December 9, 2016 that address the establishment of the issue price of an issue of tax-exempt obligations for purposes of Section 148 of the Internal Revenue Code relating to arbitrage and rebate. I am Victoria Ozimek, a partner in Bracewell's Public Finance section. I am based out of the firm's Austin office and specialize in advising our clients regarding all aspects of tax-exempt obligations. Presenting with me today is Brian Teaff, a senior associate in our Houston office. Like me, Brian devotes a substantial amount of his time on tax matters relating to tax-exempt obligations. He also counsels public charities and private foundations on a wide range of tax planning and compliance matters. So I thought it would be helpful to talk a little bit about the agenda we will be covering. What we will not be covering today is going through all the policy and practical reasons why Treasury did not get it right. That's a well-trod road. There are numerous comments that have been submitted to both the 2013 and 2015 proposed regulations. They go over all of these policy and practical reasons, and apparently Treasury didn't buy it all. So what we are going to talk about today is starting off with a brief chat about why we even care about issue price. And once we figured out why issue price matters to us, Brian will take us through the annals of issue price so that everyone will have a little context regarding how we got where we are today. I'll take the reins back to walk through the rules of engagement for the uneasy compromise of the final regulations, setting the scene for our new normal. Finally, Brian and I will gaze into our crystal ball that will reveal what issues the industry will have to put our heads together on. So let's begin. Since the release of the new regulations, we've received calls from a lot of people asking us essentially, what's the big deal? Why is establishing the issue price so important anyway? Most of those asking the questions know that issue price is important for determining arbitrage yield, which is the yield to which issuers must yield restrict, subject to any temporary periods or other exceptions, their investment earnings on bond proceeds. Since 2008, yield restriction hasn't been that difficult, as the days when investment yields were anywhere close to the bond yields are becoming a distant memory. However, back in the pre-2008 days, issuers pushed their investment yields to the limit of what was materially higher than the bond yield. Knowing what that limit is without going over was essential to maintaining compliance with the yield restriction rules, and thus the tax-exempt status of the bond. What many don't immediately realize is that bond counsel use issue price as a surrogate for many other rules in the regulations. For example, we use it for a surrogate for sales proceeds, face amount, proceeds, etc., to measure compliance with a number of other tax requirements necessary for an obligation to be tax exempt. For example, the issue price of bonds is generally considered to be equivalent to sales proceeds, which is the basis for measuring compliance with the private activity limitation. Many bond counsel also, in certain circumstances, use issue price to determine compliance with the $10 million limitation for bank qualified obligations. The calculations for weighted average maturity, which is reported on the 8038, are based on the issue price of the bonds, as is the measurement on the limit of a reasonably required reserve fund. For private activity bonds, bond counsel use issue price to measure compliance with the 2% cost of issue limitation and to determine the amount of volume cap that the issuer must receive. So as you can see, there are a lot of reasons why we care about what issue price really is. Now, to give us a little bit of context and background on why or how we've gotten to where we are today, I'm going to turn it over to Brian to discuss a brief history of the issue price.
Ordinarily, we wouldn't bore you with details regarding the history of a set of regulations, but in this case, I think it's helpful to briefly discuss how we got where we are, and also to understand a little bit of Treasury's justification for in their policy for the new regulation, but also to serve as a reminder that although we may not love the final regulations, they could have been a lot worse. So the start of our journey is in 1969 when Congress introduced the concept of arbitrage bonds. And obviously, what they were trying to prevent here was the prototypical device where a state or local government would borrow money at the lower tax-exempt interest rate and then reinvest the proceeds in higher yielding investments. Because of this, the calculation of yield became a very important concept. So under these rules, The yield on the issue was calculated based on the purchase price of the bonds minus cost of issuance paid directly by the issuer. And this was the rule until 1978, when Treasury released regulations basically on the concern that allowing issuers to deduct cost of issuance motivated marginal advance refundings and excessive consultant fees. And so to combat this perceived abuse, Treasury passed regulations that required that cost of issuance be included in the purchase price when the yield was calculated. Now, the 78 regulations were subsequently struck down in 1982 in a case called State of Washington on the ground that Treasury exceeded its regulatory authority. But for what it's worth, it's a good reminder that we've been fighting about, or at least discussing, about, the concept of calculation of purchase price or issue price for yield purposes for quite a long time. In 1986, Congress specifically overruled the court's holding in State of Washington by enacting Section 148 of the Code, which introduced the concept that yield is to be determined based on the, quote, issue price of the bond. Issue price was defined in the conference report as the price at which a substantial number of bonds are sold to the public and must reflect a current market price. Treasury and IRS released several different iterations of proposed regulations to the 86 law, and ultimately in 1993, the then and current final issue price regulations were released. So under these current rules, which are effective until June 7, 2017, the issue price of an issue of publicly offered bonds is the first price at which a substantial amount defined as 10% of the bonds is sold to the public. The term public does not include bond houses, brokers, or similar persons or organizations acting in the capacity of underwriters or wholesalers. So what we have here is an actual sales test component, which, as you will see, is also present in the new issue price regulations. However, under the current rules, as I'm sure you all know, in the case of a bona fide public offering, whatever that means, and we'll get to that, the issue price is determined as of the sale date based on the reasonable expectations regarding the initial offering price of the bond. So I say whatever that means with respect to a bona fide public offering, because the term isn't actually defined in regulations, and in fact, in subsequent comments and guidance requested by various industry groups, there has been requests for a bona fide public offering to be defined. But nevertheless, putting that aside, since 1993, we've been operating under a universe in which the reasonably expected offering price of the bonds in a publicly offered deal constitutes the issue price. And what's important about this is this has allowed us to enjoy certainty as of the sale date as to the issue price of the bonds. With respect to privately placed bonds, although it's not specifically stated in the current issue price regulations, the issue price is generally considered to be the price paid by the initial purchaser of the bond, and this is just consistent with other provisions of the regulation not specifically addressing the arbitrage of tax-exempt bonds. So in the mid-2000s, the IRS began to question certain aspects of issue price. And before we briefly touch on these, we just want to note and stress that these were concerns raised by the IRS, which we certainly don't necessarily endorse, and they've been rebutted by market participants. But we raise them because we think it's helpful in understanding the IRS's and Treasury's motivation, and helps us understand sort of how we arrived at the new rules. So in 2006, in certain IRS examinations of bond issues, agents began to notice some inconsistencies between what was reported by the issuers and what appeared on EMA. So specifically, these agents concluded that the reasonable expectations test wasn't always representative of what actually happened, what actual sales reflected. So the IRS began to question whether underwriters may be selling the first 10% of the bonds at a very low price and then selling the remainder of the bonds at a higher price. Alternatively, the IRS questioned whether underwriters were selling bonds to another dealer or institutional investor who then sold them again simultaneously, with the prices rising continually before bonds were actually sold to the investors. And then finally, although a detailed discussion is beyond the scope of this webinar, we would note that some of the activities engaged in by Edward Jones are similar to the type of perceived abuses that the IRS was concerned about. And then finally, the question of issue price also came up in 2009 in connection with the Build America Bond program, which, as some of you may recall, BABs could not be sold with more than de minimis amount of premium. So again, issue price became an important concept. And industry groups like GFOA, NABL, Bond Dealers of America, and SIFMA sent a letter to Treasury noting that the existing definition based on reasonable expectations continues to be the best approach, but requested clarification on the meaning of bona fide public offering, the definition of public, and what would constitute proper evidence of initial offering prices. So that's a little bit of the history setting the stage for the new final regulations. But as you may recall, they were preceded by two sets of proposed regulations. So let's briefly talk about those. The first iteration of the proposed issue price regulations occurred in 2013. They represented a draconian shift from the current rules, if they would have specifically eliminated the reasonable expectations test entirely and would have defined substantial amount as 25% of the bonds sold. So in other words, under the 2013 proposed regulations, the issue price of the bonds would not have been set until 25% of the bonds were actually sold to the public. This would have resulted in significant uncertainty. Questions arose whether the BPA could be signed on the sale date if 25% of the bonds hadn't been sold at that time, or even whether the bonds could close at all if issue price hadn't been determined by the issue date. So needless to say, the 2013 proposed regulations were significantly commented on by those in the industry and generally objected to. The IRS took those comments into account and reproposed the regulations in 2015. So in 2015, they would have also eliminated the reasonable expectations test, but returned to a substantial amount being defined as 10%. But also incorporating the bond community's desire for certainty, the 2015 proposed regulations incorporated an alternative method that stated that the issue price could be the initial offering price of the bond sold to the public as of the sale date, so long as the lead or sole underwriter certified in writing to the issuer that no underwriter filled an order from the public after the sale date and before the issue date at a higher price, unless market changes justified the higher price, which would have to be documented by the underwriter. So, stated differently, although this was a better test than the 2013 proposed regulations, in that it would have allowed the underwriters to, and the issuers to receive some level of certainty, it certainly wasn't without issues. For example, questions arose as to what it meant for prices to be higher because of market changes. People questioned what kind of diligence did issuers and bond counsel have to do to verify any changes in the market price. And people questioned whether lead underwriters were really even going to provide certifications about the actions of other members of the syndicate. So with that history in mind, I'll turn it over to Victoria to discuss how Treasury and IRS incorporated the history of the regulations and the 2013 and 2015 proposed regulations into what we now have as the new final regulations.
So currently we have what has been proposed and now deemed final is the uneasy compromise of the final regulations. And then I say uneasy because the government feels like it has addressed the comments and market considerations that were brought up in the comments, but the industry still seems like we're wishing we could have stayed with the devil we knew and feeling like a fly had been swatted with a sledgehammer. They represent a compromise, though, and certainly they represent an improvement from the 2013 and 2015 proposed regulations. And so at this point, as we've mentioned before, there's not much we can do about changing the regulations. There might be some nips and tucks as we move forward. We should expect maybe some guidance and clarifying points, but there won't be probably any major changes to these final regulations. So we have to figure out what to do with them. The first thing to note is that the effective date of the regulations is June 7, 2017. That applies to bonds that are sold after June 7, 2017, not bonds closing after that date. So we'll have to pay attention to the sale date of the bonds when we're trying to figure out which of the current or the final regulations apply. Another thing that was clarified in a industry teleconference was that this effective date was by design. Many times when Treasury releases regulations, they allow issuers to elect into the final regulations early, before the effective date. Treasury has indicated that this was specifically not done in this case because they were hoping that there would be time for the market to work things out. They didn't want to see any issuers rush into sort of fixes that weren't really readily accepted by the market and other industry participants. So we have approximately 6 months to work this out. And again, these represent a compromise. The final regulations provide accommodations for competitive sales and a narrower definition of the underwriter, but they also impose new rules that we're all going to have to put our collective heads together and work through. So going through the final regulations, I'm going to start with some key definitions. And as we go through the following slides, the terms public and underwriter will play an important role. And we apologize for the small print and committing the cardinal sin of PowerPoints of including exact language, but the literal text of the definitions here are important. The first is the definition of public, and it's defined as any person other than an underwriter or a related party to an underwriter. So it's defined in the negative. This is different than the current regulations, in which public is specifically defined to exclude bond houses, brokers, or similar persons or organizations acting in the capacity of underwriters or wholesalers. So it's a much shorter definition. But what the current regulations didn't do, and what the new regulations do is define what an underwriter is. There was a great amount of hand-wringing under the current regulations as to whether the public would include a bank who acts as an underwriter in some deals, but is not in any sort of contractual privity with the issuer. I think Bond Counsel took differing positions on this. And I think the final regulations do clarify that if you're not acting as an underwriter in connection with the deal that is being sold, you are considered a member of the general public. So going through the definition of underwriter, an underwriter is any person that agrees pursuant to a written contract with the issuer, so there's that element of contractual privity, to participate in the initial sale of the bonds to the public. So it's an entity that's participating in that initial sale of the bonds to the public, directly or indirectly, with a person described above to participate in the initial sale of the bonds to the public. So it would include a retail distribution agreement between a lead underwriter and a regional firm. So having gone through those definitions, we'll go to the general rule. And the general rule is going to look pretty familiar because it really isn't much of a departure from what the rule is in the current regulations, which is that the issue price is the first price at which a substantial amount, or 10%, of the bonds is sold to the public. Now, where we are going to deviate from the current rule is that reasonable expectations are going to become irrelevant under this new general rule. The other piece of the general rule is that the issue price for a private placement with a single buyer is the price paid by that buyer. Now, really, this is just something that follows naturally from the general rule, because if you have a single buyer who is purchasing all of the bonds, well, then you have 10% of the bonds being sold to the public because that single buyer is not an underwriter. But Treasury has indicated that they included this provision in the new regulations not to signify any change or departure from the old regulations or the old methodologies, but simply because people requested that it be included and clarified in the comments. So now we're stuck with this general rule, 10% of actual sales. But understanding that in many cases, an issuer is going to want to determine what the issue price is before the closing date. And at times, 10% of the bonds might not have been sold prior to the closing date. There are a couple of special rules that allow you to rely on reasonable expectations. Now, the first one is what has become known as the hold the offering price rule. And in this case, an issuer may treat the initial offering price to determine the issue price as long as it meets certain requirements. So in other words, an issuer can rely on reasonable expectations if it meets all those requirements. The first of that is that bonds must be sold to or offered to the public for purchase at the initial offering price on or before the sale date. This shouldn't really create any big ripples in the market because that's really what is, has been come to be expected by industry and participants, is that the bonds will be offered to the public. So the second requirement that is required for the hold the offering price rule is that the lead or sole underwriter provide to the issuer on or before the issue date a certification regarding the initial offering price to the public. This, again, isn't much of a departure of current practice. Bond counsel routinely requests that the lead or sole underwriter sign the issue price certificate. Now, the difference being that this new requirement also requires that there be reasonable supporting documentation. And that reasonable supporting documentation is a copy of the pricing wire or equivalent communication. By and large, it will always be the pricing wire. When asked what an equivalent communication might be, a Treasury official said, don't really know, but we put that in there to allow for flexibility. So there is some flexibility in the rule, but we anticipate that the pricing wire will be what is attached. The final requirement is where the devil resides, in that each underwriter in the syndicate must agree in writing that it will not sell the bonds at a higher price for 5 days after the sale date, or until 10% of the bonds are sold, if earlier. This is a significant departure of where we stand today under the current regulation, which only require that the underwriter reasonably expect as of the sale date that the bonds would have sold at the initial offering price. So agreeing to hold the price for 5 days is a significant departure. It remains to be seen how often the hold the offering price rule is actually accepted by underwriters or is used by issuers to determine an issue price, because it does infuse a significant amount of market risk for the underwriters. However, in terms of context, Treasury officials have said that in determining in setting the 5 days, they saw that this was a reasonable hold period, and it was in response to the initial or the earlier proposed regulations, which introduced a much more significant hold period. They would have required that the bonds be held until the closing date, and recognizing that the difference between the sale date and the closing date could vary quite significantly between different deals. They ultimately settled on this 5-day hold period as being a sufficient amount of time for the issue price to have settled. The other special rule was for competitive sales. Again, in the initial proposed regulations, there really weren't any accommodations for competitively bid deals. Recognizing that competitively bid deals are inherently more price and transparent, the new regulations do provide this special rule. Now, some things to keep in mind is that every deal that we might, in kind of industry parlance, call a competitively bid deal might not qualify for this rule, because you have to qualify under the definition of a competitive sale. And in order to do so, there are a few requirements, some of which are easier to comply with than others. The first of the requirements is that the issuer must receive at least 3 bids from, underwriters who participate regularly in the municipal bond market. At first glance, this brings to mind the rules for bidding open market securities for refunding in escrows and GICs, which also have a 3-bid requirement. However, unlike those rules, this is not a safe harbor. So if 3 bids are not received, the issuer cannot rely on reasonable expectations. A issuer in those cases would have to fall back to the general rule, the 10% of actual sales rule, and they would also be eligible if the documents have been set up to accommodate it, the hold the offering price rule. This puts a lot of pressure on receiving 3 bids and will be discussed in more detail later. But it will also create significant changes to the notice of sale and the bid form, as bidders must be prepared for the possibility that they can't rely on reasonable expectations to establish issue price, and in such a case would have to hold the bonds if 10% of the bonds were not actually sold. As another clarifying matter, we've received a lot of questions regarding the fact that the 3 bids must have been received from underwriters. And Treasury in an industry teleconference has indicated that if a bank or some other entity is bidding for its own account, that would be considered a legitimate bid that could be counted towards the 3-bid rule. The second requirement is that there have been adequate dissemination of that notice of sale. This is probably not a requirement that's going to be too difficult to accommodate. It sounds like that Treasury was trying to accommodate industry standards by allowing the dissemination requirement to be met through electronic communication that's widely circulated to potential underwriters, which from our understanding is generally how the competitively bid deals are, how they work. Also, kind of borrowing from the rules regarding bidding open market securities for refunding escrow and GICs is the rule that all bidders have an equal opportunity to bid. There can be no exclusive last looks in the bidding process. Again, this should be fairly standard market practice as it is and not terribly difficult to meet. Finally, there's a requirement for a competitive sale that the bonds be awarded to the bidder who offers the highest price or the lowest interest cost. Again, Treasury has clarified that the references to highest price or the lowest interest cost are not technical definitions, but are meant to allow flexibility for state law definitions and requirements. So there's not too much to be read into, for example, the difference between a lowest interest cost versus the lowest true interest cost or the NIC. The Treasury had, they've drafted these to accommodate some deviations between different states. And so finally, under the special rule for competitive sales, the winning bidder must certify as to those reasonably expected initial offering price upon which the bid is based. This, again, shouldn't create too many problems, as issue price certificates are, kind of generally required by bond counsel to close competitively bid deals as it is. So that's our second special rule. So now the final regulations, and we put this slide up just to show, stated another way, essentially. The final regulations are set up so there's a default general rule with 2 special rules. So there's the general 10% of actual sales, with the 2 special rules being the hold offering price rule and the competitive sales rule. But we've reorganized it in this slide to show it more or less on how the industry divides sales. We think of sales in terms of negotiated sales, competitive sales, and private placements. And so this slide is just meant to sort of reorganize the rules for everybody to see what rules might apply in those different situations. And now some kind of miscellaneous elements of the final regulations. The first is, how do we choose which rule applies? We have these 3 rules to choose from, and obviously if we don't have a competitively bid deal, we're not going to be using that rule. But how do we decide what rule applies to a specific maturity of the bonds? And if more than one rule is available, it's very clear from the regulations that the issuer may select the rule it wants to determine the issue price of the bond so long as it does so on or before the issue date. And it must identify the rule selected in its books and records maintained for the bond. Ostensibly, that will be likely through in the federal tax certificate itself. But even this provides that even if the issuer, for example, has sort of set everything up so that the hold the offering price rule could be accommodated, if it in fact later sells 10% of the bonds at a different offering price, let's just say that it's at an offering price that is more amenable to them, then they can decide to rely on the general rule instead of the hold the offering price rule. So it does allow for some flexibility there, but they have to decide before the issue date. Also, the final regulations make clear that separate determinations can be made on a maturity by maturity basis. Tax-exempt bonds or municipal bonds are a little bit unique in the fact that serial bonds are pretty much widespread, and so that has been a challenge in setting issue price in the past. And so the new rules state that the issue price of bonds in an issue that do not have the same credit and payment terms can be determined separately. Many people joke that the important facts are always hidden in the footnotes, and here it's the IRS seems to kind of think that that should also be used for the preamble to the regulations, which is the sort of explanation of the regulations that is included in the release. Now, kind of tucked away, sort of 3/4 of the way into the preamble, is a note that the issue price could change, and basically states that the failure to meet any requirement. So, for example, if an underwriter breaches the hold the offering price rule, or if the underwriter in fact did not sell 10% of the bonds at the initial offering price. If it's determined that those are the facts and that they failed to meet that requirement, the Internal Revenue Service states that the issue price will be redetermined, and that's a pretty big deal, and is a departure from the current rules, which provide that once the issue price has been set, that's always the issue price, and you can rely on it and move forward. We'll talk about that a little bit more in detail later, but that's a pretty significant change tucked away into the preamble. The preamble also notes that there's the standard of reliance on certificates is the prudent person standard. Again, it's not a change from what we rely on now. The significance is just that it's a change back from what was in the proposed regulations. So there was a higher standard that was imposed in the proposed regulations, and the IRS has determined to move back to the prudent person standard. Finally, also tucked away in the preamble is the provision that the underwriter might be subject to Section 6700 penalties if there's a false statement made by an underwriter. And so this really ties back into the fact that the issue price could change. If an underwriter, again, signs an agreement saying that they're going to hold the offering price and then does not do so, depending on the facts and circumstances, the IRS might impose the Section 6700 penalty against the underwriter, and we'll talk a little bit more about that later. But for now, I think the directive is to kind of keep calm and sell some bonds. We get it. The new regulations are going to require some changes to the way that we do business. However, in light of the 2013 and 2015 proposed regulations, things could have been a lot worse. The IRS received hundreds of comments to all of these regulations, the proposed regulations, and it seems that they really did try to make an effort to accommodate a lot of those comments. But one thing's for certain, they weren't going to stick with the status quo and certainly didn't do so. So again, there might be some clarifying comments made, as we move forward towards that June 7 effective date, but we shouldn't expect any major changes. So what we need to do now is, kind of make sure we all understand the new rules and are interpreting them consistently. We need to figure out how we're going to do business under this new set of rules that we have. And we all need to recognize that we bring different perspectives and expertise to this process. So we're all going to have to bring those different perspectives together so that we can find a workable solution. So at this point, it's our time to try to predict what some of those changes are going to be. And you know, I think it's probably obvious, but it bears saying that you know, anything that we say from here on out is just, you know, a prediction. And so keep that in mind as we move forward and talk about what we see as potentially being some of the issues that we need to work through. The first are market effects. You know, obviously, when rules change, they have practical effects, and one of those is where the market for the bonds is going to go. So some of the questions, you know, that we have here are, you know, will the final regulations result in lower offering prices in order to satisfy the general rule? Because there is, you know, a desire to have some certainty with respect to the issue price, and there might be some pushback or some struggles in getting everything worked out with the hold the offering price rule. It's potentially what could happen is, you know, we move towards lower offering prices just to make sure that 10% of the bonds can actually be sold. Also, you know, how will the final regulations affect the number of bids received in competitively bid deals? Competitively bid deals, you know, I think that at least the process and the documentation on competitively bid deals is what's going to change the most. You know, I feel like there are standard operating procedures that we use. We have forms, you know, pretty well worked out, but we're going to have to see a lot of those change in order to accommodate the potential for getting fewer than 3 bids and having to kind of shift issue price regimes in midstream. Some questions that, you know, we'll kind of have to work through in that regard are, you know, whether this will be sort of a self-fulfilling prophecy, whether other underwriters who might otherwise bid on competitively bid deals are sort of cooled to the market and determine that, well, hey, because of the risk that we might not get 3 bids, I don't want to bid on it, and thus the issue gets less than 3 bids. And finally, you know, there's always a demand dynamic in pricing the bond. Certainly, if customers, you know that there's an incentive to have 10% of the bonds actually be sold, that's going to affect the dynamic of the demand. So it might affect how bonds are being priced.
So another sort of gaze into the crystal ball considers variations in structuring and application. So what do we mean by that? Well, as Victoria mentioned above, you know, it's possible to group the new regulations generally in 3 broad categories. But there might be deals that do not necessarily fit within one of those categories, and so we're going to have to think about how that affects both the process and the documentation. So, you know, for example, one thing that might happen, and Victoria touched on this, is a situation where the bonds are competitively bid, but the bonds are not sold pursuant to a, quote, competitive sale in accordance with the new regulations, you know, most likely due to the fact that maybe 3 bids were not received. And so how would we address this situation? Well, I think, you know, the first thing to note is the general rule would apply, and the issue price would be the first price at which 10% of the bonds were actually sold by the winning bidder to the public. However, if the documents were drafted accordingly and the winning bidder was willing to agree to this, the issue price could be based on the initial offering price as long as the requirements under the hold the offering price rule were satisfied. Another sort of variation that doesn't fit neatly within the 3 categories would be a situation where everything is set up as if the hold the offering price rule is going to apply, but the underwriters actually sell 10% of a maturity at a price less than the initial offering price before the issue date. And so in such a case, I think the new regulations because of their ability, because they give the issuer the ability to sort of pick and choose which rule will apply, you could presumably result in a sort of awkward situation where the issuer elects to base the issue price on actual sales, even though economically it's going to receive a higher price that's based under the BPA that was based on the reasonably expected initial offering price. So, you know, we don't necessarily have answers to how we're going to address this at this time, but it's something that we're definitely going to have to continue to consider and analyze. And then the final variation would be in something that we consider to be a private placement, sort of plain English private placement, but that does not strictly fit within the definition of private placement under the new regulations. As Victoria noted, the new regulations define private placement as a sale to a single buyer that is not an underwriter. Well, what happens if the sale is to two buyers who intend to hold the bonds for their own account, but neither of whom is an underwriter? Well, it's not a, quote, private placement because it's to multiple buyers, not a single buyer, but maybe the result is the exact same because the general rule would apply. And since more than 10% of the bonds were sold, you get to the same place. But you could also think of a situation in a private placement where the bank purchases the bonds and doesn't fit within the definition of an underwriter because there's not that contractual relationship that's required. But the bank intends to flip the bonds or put them into a securitization trust structure. And so we're going to have to think about whether anything special needs to be done in that scenario to establish that the issue price is in fact the price paid by the bank for the bonds. We've heard, it kicked around that, perhaps issuers would require, a certification from the bank that they'll hold the bonds for at least 5 business days before they're resold or put into the trust. So again, that's just something that we're going to have to monitor as we continue to think about these regulations and get input from the market.
As I mentioned before, towards the end of the preamble, the IRS rather offhandedly provides that a failure to meet a specific eligibility requirement of a rule for determining issue price, such as the hold the offering price rule, and a redetermination will result potentially in the redetermination of issue price under a different rule. So you might move from having relied on reasonable expectations because you thought that the hold the offering price rule was met, but in fact have to go back and redetermine the issue price based on the first price at which 10% of the bonds have actually been sold. As I also mentioned, this was not part of the prior regulations or the regulations that we currently operate under. Currently, once you've set the issue price, that's the issue price. And so basically my reaction to this is, wow, I mean, this is a big change. And admittedly, it's a little bit hard for me to get my head around all the ripple effects this could potentially have, especially if it's found that issue price is going to be used or can still be used for the determination of non-148 type requirements such as volume cap, the 2% cost of issuance rule, those types of things. Now, kind of, assuming for a moment that we're just talking about 148, let's talk about what the result of that would be. The first thing that probably comes to mind for most is that the bond yield will change, pretty obviously, and then a higher issue price, as you all know, would result in a lower bond yield. So if an issuer, and again, we're assuming pre-2008 markets here, but if an issuer has been yield restricting to a certain bond yield, it might have the rug pulled out from under them if suddenly they get notified that they should have been yield restricting to a lower bond yield. And it might result in the bonds becoming taxable. There's been some talk about whether or not there would be a special yield reduction rule introduced so that an issuer could kind of rectify the situation through a yield reduction payment. But until that magically appears, what kind of the end of the road is that you're going to have taxable bonds on your hands. And of course, taxable bonds, usually it does not come to an actual declaration of taxability. Usually there's a settlement paid by an issuer to the IRS, and who's going to pay that? And to the extent that even if we walk back towards paying a yield reduction payment, if an issuer hasn't been budgeting that, that's going to be a big burden for an issuer to suddenly have a yield reduction payment come up that it needs to make to protect the tax-exempt status of the bond. Now, even setting aside yield, just pure yield for a moment, under 148, there are certain spending expectations that, for temporary periods, you have to have spent all the bonds. I query what will happen if you have a higher issue price. It results in sort of this odd situation where an issuer might be asked to account for amounts that it never received. If you, received initially, $100 for your $100 worth of bonds, and it's later determined that the issue price should have been $102, well, the issuer still didn't receive that $2, but it creates some little quirks in how you account for whether bond proceeds have been spent. So that's really what I'm getting at for, it's hard to really get your head around all the different effects that a change in the issue price could potentially have. But also tucked away in this preamble is a caution to underwriters that if an underwriter makes a false statement in connection with the establishment of issue price, the underwriter could be subject to Section 6700 penalties. But as currently in effect, the penalty under 6700 could be as much as 50% of the underwriter's compensation for the transaction. So that's not insignificant to think about in terms of the penalties that could be imposed on an underwriter. The threat that the issue price could change in the future and cause bonds to become taxable, as well as the threat of underwriter penalties under Section 6700, really have the potential to change the dynamic of the relationships between the various parties involved in the transaction. And so Brian's going to talk about that a little bit more now.
Right. So anytime we start getting into redetermination of issue price and potential for penalties, we're going to start to look to allocate risk. And so presumably issuers may be looking to the lead underwriters for indemnification in the event that something goes wrong and the issue price changes and it requires the issuer to have to come out of pocket. And then similarly, the lead underwriter presumably may be looking to the syndicate members in the event that it's one of the syndicate members that breaches a requirement under, for example, the hold offering price rule. So it's possible that you could even have discussions between the issuer and other consultants regarding, such as financial advisors and so forth, regarding what exactly, where's the risk going to be allocated and who's going to pay, essentially, in the event that that the issuer has to come out of pocket. Obviously, allocating risk is going to require presumably indemnification provisions or something similar that's going to be specifically addressed in documents. So Victoria is now going to talk about sort of where we look into the crystal ball and where we think changes to documents or what documents might occur.
Yeah, some of the changes to the documents are pretty obvious. The first being the issue price certificate. If you change the issue price rule, well, the issue price certificate, the language of it is going to change. So that's a real obvious one that, will require some back and forth, but I think everyone's sort of expecting that to come down the road. As Brian mentioned, the new rules also really changed the dynamic and the agreements between not only the issuer and the underwriter or the lead underwriter, but also the lead underwriter and all the members of the syndicate. For example, the new regulations make clear that the hold offering price rule needs to be made with each underwriter. Also is pretty clear that the different underwriters are severally liable for their piece of their issue. And so all of those things and the agreements and the relationships need to be worked out in the bond purchase agreement and the agreement among underwriters. And from what we understand, SIFMA and the National Association of Bond Lawyers are working together to develop forum language that can be used by all industry participants for those documents. That's especially important in the agreement among underwriters, which are generally kind of very standard documents that are used by all participants and aren't really negotiated. Another document that will likely see some changes is the official statement. And I say that in part because of this redetermination of the issue price rule. There are certain risk elements that obviously that will introduce that will need to be disclosed in the official statement. The notice of sale in the official bid form will change for competitively bid deals. Like I mentioned before, I think competitively bid deals are probably those that are going to see a very significant amount of change in standard form documents, because it will have to sort of accommodate this either or situation if 3 bids are not received. Finally, the tax certificate and the certificate of financial advisor will also likely see some changes, again, probably mostly so for competitively bid deals, because certain certifications regarding the bidding process will need to be received by the parties involved. So, these won't be simple, small changes. We're talking about, lots of different documents changing. It also probably is worth mentioning that it's possible that kind of form opinions will also change as a result of the new regulations.
So thanks, Victoria. I think our overarching goal of this webinar is to just introduce everybody to the fact that these new regulations are going to have a significant impact on the municipal bond market. While the text of the regulations is not particularly difficult to understand, the challenge is going to be how all of us will incorporate the new regulation into our transactions and into our respective businesses. If you have any comments or questions, please don't hesitate to contact Victoria or me, as well as any other member of Bracewell's Public Finance Group.